I'm Mia Doncevski. I'm a solicitor here at Solari and Stock Lawyers, and I'm here to talk today about what an enduring power of attorney is and why you might need one. So, an enduring power of attorney is a legal document that allows a person to appoint an attorney to act on their behalf in relation to their legal and financial affairs. And this might include buying and selling assets such as real estate or operating bank accounts. The attorney cannot make health and lifestyle decisions, and that's covered by a separate document called an enduring guardianship. I will be doing a separate video about enduring guardianships as well if you're interested. An enduring power of attorney can be broad, such that your attorney can be granted the authority to act on your behalf of all of your legal and financial affairs, or it could be limited to just certain tasks that are specified in the document, such as buying and selling real estate. You can also place conditions on how the tasks are carried out, such as requiring that an attorney is to submit accounts to your nominated accountant every year for an audit. You can decide when your enduring power of attorney commences. For example, it can commence immediately, or it can commence once a medical practitioner deems that you no longer have capacity to make those decisions for yourself. This might be because of a loss of mental capacity, and once mental capacity is lost, you cannot revoke your enduring power of attorney. So that's why it's important to put it into effect prior to that happening. An attorney cannot deal with a person's assets after the death, so they are lifetime documents and they only operate while the person is alive. And once a person dies, their enduring power of attorney no longer has any effect, and the will then comes to effect. So why might you need an enduring power of attorney? It is a common misconception that enduring powers of attorney are documents that are reserved for the elderly. However, that is not the case, and we generally advise all our clients to consider preparing an enduring power of attorney document as part of their suite of estate planning documents. If you do not prepare an enduring power of attorney and capacity is lost, you cannot make the decision as to who will be your attorney to deal with your legal and financial affairs, and someone will need to make an application to NCAT to be appointed as your financial manager. Having a power of attorney in place ensures that the selection of the person in control of your financial affairs in the event that capacity is lost remains in your control and saves your loved ones from having to go through the process of appointing themselves as manager at NCAT. If you hold concerns that the person you have appointed might be unwilling or unable, you can appoint them jointly and severally with an additional person, or appoint a person to act as a substitute in the event that the first person you've selected is unable. If you have any questions about preparing an enduring power of attorney or would like to prepare one, feel free to contact our office and speak to one of our members of their Wills and Estates team. Thanks for watching.